Civil litigation does not operate on the element of surprise. It is a rigid process built on the exact opposite principle, forcing opposing parties to lay their cards on the table long before they ever step into the courtroom. To achieve this, litigators rely on Rule 25 of the Rules of Civil Procedure, interrogatories to parties. It is the specific mechanism designed to compel an opponent to answer written questions under oath, locking in material facts. We are going to map the strict procedural mechanics of this rule. We will dissect the mandatory timelines, the strict initiation requirements brought by the 2019 amendments, and the fatal procedural traps that can permanently block you from calling your opponent to the witness stand. Executing Rule 25 correctly ensures you maintain the tactical high ground. Failing to use it means stepping into trial completely in the dark. Section 1 defines the strict initiation protocol. It establishes that written interrogatories are directed exclusively at an adverse party to elicit material facts. Target selection is critical. If you need information from someone who is not an adverse party, an ordinary witness, for example, Rule 25 does not apply. You must secure their testimony via deposition or subpoena under Rule 23. Looking at this timeline blueprint, the process begins with an absolute prerequisite. Under the 2019 amendments, a party must file an ex parte motion and secure court approval before serving written interrogatories. This is a strict departure from the older 1997 rules. Previously, a litigator could serve interrogatories without court intervention, as long as the defendant had filed an answer. That automatic right no longer exists. Attempting to serve an ordinary witness or failing to file the required ex parte motion voids the discovery attempt at the starting line. Once the court grants the motion and the interrogatories are served, Section 2 takes effect. The adverse party is mandated to answer fully, in writing, and under oath. This clock tracks the reglementary period. The receiving party has 15 calendar days from service to file sworn answers. This default deadline is not rigid. Upon motion for good cause, the court exercises discretion to extend or shorten this limit. The answers provided must be sworn to by the person making them. If the receiving party submits an unverified document or forgets to sign under oath, the rules treat those answers as legally non-existent. Missing the 15-day deadline or failing the oath requirement subjects the refusing party to severe sanctions under Rule 29. The court can strike out pleadings, dismiss their action entirely, or immediately enter a default judgment. Section 3 provides the target's primary defense mechanism. It allows a party to shield themselves from questions that are irrelevant, oppressive, or legally privileged. This shows the narrow defensive window. Objections to interrogatories must be presented to the court within 10 calendar days after service. Filing this hits the procedural pause button. The obligation to answer is deferred until the court resolves the dispute. If a party attempts to file an objection on the 11th day, the window is closed. The court will reject the late filing. The 10-day objection window is a strict safeguard. Missing it waives the right to contest the questions, forcing the party to disclose potentially damaging information. To prevent discovery from becoming a tool for harassment or undue financial burden, Section 4 imposes a strict volume control on the litigator. This diagram illustrates the general rule. A litigator is limited to serving exactly one set of interrogatories upon the same adverse party. Attempting to serve subsequent sets of questions triggers an immediate procedural block. The secondary questions carry no legal weight. To legally bypass this single-set limitation, the propounding party must secure explicit prior leave of court. The rules presume that multiple sets of interrogatories are abusive. Without a specific judicial order granting an exception, any secondary set is entirely void. Section 5 sets the substantive boundaries, defining exactly what subject matter can be targeted by these written questions. Rather than creating a separate standard, Rule 25 directly imports its scope from Section 2 of Rule 23 on depositions. This permits broad inquiry into any matter relevant to the pending action. Litigants can probe the specific claims, defenses, and crucially, the existence, custody, and exact location of tangible documents and things. The absolute limit to this inquiry is legal privilege. Interrogatories cannot penetrate strictly privileged communications, such as those protected by the lawyer-client or doctor-patient relationship. Once the answers are sworn and returned, they function with the exact same lethal utility as a deposition. They are deployed at trial to secure admissions against interest
or to impeach a witness on the stand. Section 6 acts as the punitive enforcer of pretrial discovery. It is designed to force parties to investigate before trial, rather than conducting fishing expeditions in front of a judge. If a litigator fails to serve written interrogatories, they trigger a devastating penalty. They lose the right to compel that adverse party to testify. That failure carries a secondary penalty as well. The negligent party is also barred from compelling the adverse party to give a deposition pending appeal. This extends strictly to corporate entities. Jurisprudence, specifically the ruling in Afaluquisia v. Metrobank, confirms that if a corporation is not served with interrogations, you cannot compel its officers to testify as adverse witnesses. The only way to override this prohibition is to prove to the court that good cause exists and that an exception must be made to prevent a failure of justice. Bypassing Rule 25 permanently strips you of the right to extract live testimony from your opponent, effectively neutralizing your ability to cross-examine their version of the facts. Rule 25 is the foundational architecture of trial strategy. It forces the facts into the light on a strict procedural timeline. This diagram maps the entire workflow, securing the initial ex parte motion, enforcing the 15-day window for sworn answers, and navigating the 10-day period for formal objections. It requires strict discipline, adhering to the single set limit while maximizing the substantive scope borrowed from Rule 23. These mechanics are not suggestions. They are the rigid parameters enforced by the highest judicial authority to ensure fair play. Executing each step precisely secures the necessary admissions, protects your client from procedural default, and avoids the fatal trap of an empty adverse witness chair. The trial is won in the discovery phase. Mastering Rule 25 is how you ensure you never fight in the dark.